Unit 25 Securities and Charges JAIIB Principles and Practices of Banking Module B Page number 90 Types of charges over securities. Creation of charge by the debtors on various kinds of securities or assets means creation of right in favor of the creditors to get payment of the loan amount out of the security charged. By creation of charge, the ownership is not transferred in favor of the creditor, except in transactions such as English mortgage. Various kinds of charges over securities. Nature of security, immovable property. Types of security, land and building. Kind of charge, mortgage. Defined in Act, Transfer of Property Act, Section 58. Nature of security, actionable claims, that is unsecured debts. Types of security, book debts, FDR, NSC, life policies. Kind of charge, assignment. Defined in Act, Transfer of Property Act, Section 130. Nature of security, movable property or goods. Types of security, plant and machinery, stocks, vehicle, etc. Kind of charge, pledge or hypothecation of lying. Defined in Act, Indian Contract Act, Pledge, Section 172. Hypothecation, SARFAESI, Section 2. Nature of security, paper securities. Types of security, shares, debentures, mutual fund units, bonds. Kind of charge, lying. Defined in Act, Indian Contract Act, Section 170 and 171. Nature of security, personal guarantee. Types of security, promoters and third-party guarantees. Kind of charge, personal liability. Defined in Act, Indian Contract Act, Section 126. There are various kinds of charges by their nature. Fixed charge. It is created on properties such as land and buildings, plant and machinery, whose identity does not change. The debtor has no right to dispose of the assets after creation of charge without consent of the creditor. The debtor retains the ownership and possession of the assets and he can deal with them, subject to priority created by the charge. Floating charge. It is created on assets which undergo change, open bracket, stock, close bracket. It is an equitable charge on the assets of a going concern. Example, cash credit against hypothecation of stocks. In floating charge, the security is allowed to be used in the ordinary course of business until the charge crystallizes. Crystallization means when the company ceases to be a going concern or upon the commencement of winding up or on the appointment of a receiver. Pari passu charge. Pari passu charge is created in favor of several creditors with the condition that they have equal priority subject to maximum of their share in the security linked to the amount of their loan. It is generally created in case of consortium accounts. Exclusive charge. Only one creditor having the charge of the assets without intervention of any other creditor is called to have exclusive charge. For instance, assets charged only to Bank B for cash credit facility. First charge, where assets are charged to a creditor on first basis, that creditor has the first charge. Second charge, where assets are already charged to a creditor on first basis and subsequently charge is created in favor of another creditor. The second creditor is called to have the second charge. The rights of second charge holder are subject to the rights of first charge holder. Hypothecation. As per securitization and reconstruction of financial assets and enforcements of Security Interest Act 2002, Section 2N, hypothecation has been defined as a charge in or upon any movable property, existing or future, created by a borrower in favor of a secured creditor without delivery of possession of the movable property to such creditor as security for financial assistance, and includes floating charge and crystallization of such charge into fixed and movable property. A cash credit account, like an overdraft account, is a running account but with a fixed drawing limit within the sanction limit. Drawing limit is fixed periodically on the basis of value of the security. In such advances, the ownership as well as possession of the security remains with the borrower. A cash credit account is very convenient for the borrowers. Securities. Cash credits account may be against hypothecation of stocks of raw materials, stock in process of or finished goods, or stores, spares, etc. Stock statement and margins. The borrowers are required to submit to the bank a statement of stocks and other securities charged to the bank on prefixed intervals, say fortnightly or monthly. Margin. The banks maintain margin on the security, which differs from case to case depending upon the nature. Page number 91 of Security and Other Considerations. Renewals. Cash credit limits are sanctioned by the banks for a period of 1 year, where after it can be extended for further period also on review. Legal aspects in hypothecation. Possession and sale. Hypothecation is an equitable charge where the borrower keeps the possession of the security on behalf of the creditor. If the borrower fails to return the advance against the hypothecation of securities, the bank can take possession of the securities with consent of the borrower and becomes a pledgee. On becoming pledgee, the bank can get all the rights of a pledge, including rights to sell without intervention of the court. Under Securitization Act, the bank also has got the right to sell the hypothecated securities without intervention of the court, subject to compliance of certain legal formalities. Shortage. If there is shortage of securities, the pledge can bring criminal proceedings under Section 405 of Indian Penal Code. Pledge. A cash credit pledge account is like a cash credit hypothecation account. In such accounts, the legal rights are different as the possession of the securities remain with the bank while the ownership remains with the borrower. Delivery of goods pledged by the pledger to the pledgee is essential for creating a pledge, which may be actual or constructive. What is a pledge? Under Section 172 of Indian Contracts Act, pledge is a payment or delivery of goods as security for payment of a debt or performance of a promise. It may be remembered that only goods, movable assets, excluding actionable claims, Section 2 under 7 of Sales of Goods Act can be pledged. Bailment. Pledge is different from bailment. Bailment is delivery of goods by one person to another for some purpose, while the purpose in pledge is performance of a specific promise or a security for a debt. The pledgee can sell the goods pledged after giving notice to the pledgee, while in bailment the goods can be retained or bailer can be sued for charges. Who can pledge? The owner of goods, the agent of the owner, the joint owner with the consent of the other co-owner, and a person having limited interest in the goods, to the extent of his interest, can pledge the securities. Rights of pledgee. The pledgee gets the rights of a bailee, which include: A. He may retain the goods until the payment of the debt or performance of the promise is fulfilled. Goods can be retained for subsequent advances also if there is no contract to the contrary, but not for any other existing debt which is not covered by the pledge. Section 174. B. Sale of the goods by giving a due notice. Notice is must, even when specifically waived, to the pledger in case the pledger fails to make the payment of the debt. Section 176. To sell perishable goods is not the obligation of the pledge. C. To recover charges incurred for preservation of the goods pledged. D. These rights are not limited by law of limitation. E. Bank's right of pledge prevails over any other dues, including government dues, except workers' wages. Example: Supreme Court State of Bihar versus Bank of Bihar. Duties of the pledgee. A. To return the goods along with accretion to goods, if any, once the money is paid back by the pledger. B. To take that much care of the goods which he would have been taking had the goods belonged to him. Important provisions of Indian Contract Act about pledge. Section 148. Provision in summary form. Bailment is the delivery of goods by one person to another for some purpose. Section 151. Provision in summary form. Bailee to take care of goods bailed as his own goods. Section 158. Provision of summary form. Bailer to repay for necessary expenses. Section 159. Provision in summary form. Bailee to return the bailed goods on expiry of time and delivered according to bailer's direction. Section 172. Provision in summary form. Pledge is bailment of goods as security for payment of debt or performance of a promise. Section 174. Provision in summary form. Goods can be retained for subsequent debts if there is no contract to the contrary, but not for any other existing debt which is not covered by the pledge. Section 178. Provision in summary form. In ordinary course of business, mercantile agent in possession of goods may pledge validity. Hypothecation and pledge distinction. Hypothecation, defined in SARFAESI Act 2002 Section 2. N. Definition: charge on movable property in favor of secured creditor without delivery of possession. Pledge, defined in Indian Contract Act 1872 Section 172. Definition: bailment of goods as security for payment of a debt or performance of promise. Page number 92. Distinction between hypothecation and pledge. Hypothecation: parties, borrower, hypothecator, bank, hypothecatee. Nature of securities: movable assets such as stocks, machinery, vehicles. Nature of charge: equitable charge. Ownership: borrower. Possession: borrower. In trust for bank: bank cannot take possession without consent of the borrower. On taking possession, bank gets rights of pledge and can sell the assets without intervention. Delivery of goods: borrower to deliver the securities if demanded by the bank. Right of sale: available through court only, SARFAESI Act. Sale is possible after possession. Registration of charge with ROC under section 125 of Companies Act. Limitation: 3 years. Pledge: parties, borrower, pledger or pawner, bank, pledgee or pawnee. Nature of securities: goods. Nature of charge: legal fixed charge. Ownership: borrower. Possession: possession with bank till repayment of the loan. Bank has to preserve the goods carefully and return the same if loan is repaid. Delivery of goods: possession can be actual or constructive. Right of sale: available by giving notice through public auction. Registration of charge with ROC: no registration required. Limitation: not applicable. Right of line and right of set off, already covered in assignment number 12. Assignment: assignment is transfer of auctionable claim which may be existing or future. The transferor of claim is called the assigner and the transferee is called the assignee. Auctionable claim: as per section 3 of Transfer of Property Act, an auctionable claim means a claim to any debt other than a debt secured by mortgage of immovable property or by hypothecation or pledge of movable property not in the possession, either actual or constructive, of the claimant, which the civil courts recognize as affording grounds for relief, whether such debt or beneficial interest be in existence, accruing, conditional or contingent. A life policy is an auctionable claim because it is a debt payable by LIC of India for which the policyholder does not have any security in the form of mortgage, pledge or hypothecation of assets of LIC of India. Major features: A. Assignment must be in writing and signed by the assigner or his duly authorized attorney. Assignment would be effective upon executive of an instrument only, section 130. B. No particular form is prescribed for assignment. C. No consideration is essential for validity of an assignment. D. Due notice to transfer of auctionable claim is to be given to the debtor, LIC in the above example, for making the debtor liable to the assignee and his acknowledgement obtained. Such notice can be given by assignee if assigner refuses to give notice. Open bracket section 131. Close bracket. E. Assigner cannot give a better title than that what he has, as a transferee shall take the auctionable claim subject to all the liabilities and equities to which the transferor was subject in respect thereof at the day of the transfer. Open bracket, section 132, close bracket. F. Transferee can sue or institute proceedings in his own name without obtaining the transferor's consent to such suit or proceedings, and without making him a party thereto. Open bracket, section 132, open bracket, 2, close bracket. For a loan obtained by a life insurance policy holder, the bank as assignee is entitled to receive the amount of the policy and to sue on it without consent of the policyholder or his legal heirs in case of his death. Kinds of assignment. The assignments are of two kinds, that is, legal assignment and equitable assignment. A legal assignment means an absolute transfer of auctionable claim and must be in writing, signed by the assigner, and should be informed to the debtor. An equitable assignment means handing over the possession of the document representing auctionable claim without observing the above formalities. In an equitable assignment of a debt, even though there may be no regular assignment, the debtor is notified or made to understand that the debt has been made over by the creditor of the third person. Open bracket, Corporation Bank versus Lalit Air, 1994. Mortgage. As per Section 58 of Transfer of Property Act 1882, mortgage is transfer of interest in specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of loan, an existing or future debt, or the performance of an engagement which may give rise to pecuniary liability. Page number 93. Interest in property and possession. The mortgagor only parts with the interest in the property and not the ownership. Mortgage is not merely a contract, but it is conveyance of interest in the mortgaged property. As regards the possession, except for usufructuary mortgage, the possession remains with the mortgagor. Immovable property, IP. As per Section 3 of General Clauses Act, IP includes land, benefit arising out of land, and things attached permanently fastened to earth. Mortgagor and mortgagee. The transferor is called a mortgagor and the transferee is called a mortgagee. Who is to create a mortgage? Borrower. Individual who is to create himself or his agent. Borrower. Joint borrowers who is to create all or their agents. Borrower. Proprietorship firm who is to create proprietor or agent. Borrower. Partnership firm who is to create all partners. Borrower. HUF who is to create Karta. Borrower. Joint stock company who is to create person authorized by the resolution from board of directors. Borrower. Trusts or club or societies who is to create trustee or people authorized by their governing documents or resolutions. Mortgage money and mortgage deed. The principal money and the interest of which payment is secured are called the mortgage money, and instruments, if any, by which the transfer is effected is called the mortgage deed. Essential features of mortgages. A. Mortgages can be created to cover general balances, existing payment as well as future loans or advances. B. Relationship. there must be a creditor and the debt or relationship or contract of guarantee between the bank and the mortgagor at the same time at the time of the deposit. C. Future debt. Actual existence of the debit is not necessary. Even an application of debt and its acceptance establishes this relationship. Effective date. A registered mortgage and an equitable mortgage becomes effective from date of mortgage, section 47 and 48 of Indian Registration Act. E. Enhanced limits. To cover the enhanced bank limits, a supplemental registration deed is required because the mortgage already done does not cover the enhanced amount. F. Repayment of loan. On repayment of debt, the mortgage does not remain valid. Kinds of mortgages. There are 6 forms or kinds of mortgages. A. Simple mortgage, section 58B. B. Mortgage by conditional sale, section 58C. C. Usufructuary mortgage, section 58D. D. English mortgage, section 58E. E. Equitable mortgage under section 58F. F. Anomalous mortgage. A mortgage which is not of any of the above 5 kinds is called an anomalous mortgage, section 58G. Duplicate title documents. Where an original title deed is inequitable, mortgage is not available, a true copy certified by the sub-registrar can be deposited where it is proved that original is either not in existence or has been lost. Public notice of creation of mortgage is also desirable in such circumstances. Registration of mortgage. According to section 59 of Transfer of Property Act 1882, where the principal money secured is rupees 100 or more, a mortgage other than a mortgage by deposit of title deeds can be effected only by a registered instrument signed by the mortgagor and attested by at least 2 witnesses. In case the instrument is not duly attested and registered, the mortgage will be void. Under section 23 of Indian Registration Act 1908, such document is to be presented within 4 months from date of execution for registration sub-registrar of assurances. Further, in case of a company, separate registration of mortgage is required under section 125 of Companies Act within 30 days. Enhancement of existing limits. The mortgagors would be required to execute mortgage deeds for the amount over and above the amount of limit before enhancement. In case of equitable mortgage, entry is made in the title deed register for the enhanced portion of the limit by following the precautions as specified above. Page number 94. Right of foreclosure, section 67. On default by the mortgagor, the mortgagee in certain types of mortgages has right to obtain a decree before decree has been made or money has been paid from a court to the effect that the former be debarred forever to get back the mortgage property. Such a right is called the right of foreclosure. A suit for foreclosure must be filed within 30 years from date of mortgage money becoming dues. Right of redemption, section 60. On liquidation of the debt, the mortgagor has the right to get back or redeem the document relating to mortgaged property where possession has been given, to get back the possession, and where title has been transferred to get transferred. The right is known as right of redemption, which can be exercised at any time before the decree for sale or foreclosure has been passed by the court. Marshalling. Under Section 81 of TPA, if owner of one or more IPs mortgages to one person and then mortgages one or more of them to another, the subsequent mortgagee is entitled to have a prior mortgage debt satisfied out of the IPs not mortgaged to him, without prejudice to right of prior mortgagee. Limitation. Limitation period for mortgage is 12 years from date mortgage, money becoming due. For right of foreclosure and right of redemption, it is 30 years. Objective type questions.
Note for the students. Answers are given in the end of the page. Please follow that.
1. The mortgage has been defined under Section dash of Transfer of Property Act A. 57, B. 58, C. 59, D. 60. 2. A borrowing customer of yours wants to create equitable mortgage in favor of the bank. Which of the following is not true in case of an equitable mortgage? A. It can be created only in respect of a property which is specific. B. It can be created with deposit of title deed and no registration is needed. C. Deposit of title deed is made with an intention to secure a loan. D. The property to which the title deed is related should be located in a town notified by the state government. E. Place where mortgage is created should be a notified place. 3. Same property can be equitably mortgaged to two banks by the borrower. True or false? 4. An anomalous mortgage means A. A mortgage other than those 5 mentioned in the Act. B. A mortgage on which some other acts applies. C. A mortgage for which registration has not taken place with Registrar of Assurances. D. B and C. 5. Corporate bank decides to allow a cash credit limit of Rs 25 lakh to a trading firm in one of its branches in Jaipur. They proposes to secure the loan by mortgage of a commercial property open bracket located in Kolkata close bracket of the equal value in the name of one of the partners in the firm who is sick and is admitted in hospital. The firm wants the equitable mortgage to be created in the hospital itself. A. Can be accepted if the doctor certifies his illness and is one of the witness. B. Cannot be created because the hospital is not part of the bank branch. C. Can be created if the hospital is located at a notified center. D. Can be created if the title deed of the property is handed over to the bank officials. E. Can be created if the hospital would have been in Kolkata instead of Jaipur as property is located in Kolkata. 6. A loan secured by mortgage of immovable property is repayable on demand. For a personal decree against the borrower, the limitation period will be A. 3 years from date of execution of mortgage deed. B. 12 years. C. 3 years from date of the loan. D. 12 years from date of demand made. 7. Which of the following mortgages is not required to be registered with Registrar of Assurances? A. Equitable mortgage. B. Simple mortgage. C. English mortgage. D. Usufructuary mortgage. E. Mortgage by conditional sale. 8. In case of equitable mortgage, the mortgagor should not assign any document nor submit any memo in writing at the time of creation of mortgage. True or false? 9. An equitable mortgage has been created in favor of Bank A on February 1, 2009, which has not been registered, whereas a registered mortgage was created in favor of Bank B on January 28, 2009, but it was registered on February 11, 2009. Priority would be of A. Bank A because registration of mortgage by Bank B took place later than. Page number 95. B. Bank A because equitable mortgage has always priority. C. Bank B because its mortgage is registered, which has priority. D. Bank B because its mortgage has been created first. E. Both the banks have pro rata charge. 10. A company is having immovable property in Bangalore. Its registered office is in Chennai and the co is willing to avail bank limits in Mumbai, where the equitable mortgage will be created. A. Bangalore. B. Chennai. C. Mumbai. D. Any of these places. E. Chennai and Mumbai, as Bangalore is not stated to be a notified place. 11. Which type of charge is created on the book, debts or life insurance policy or national saving certificate or bank deposit in favor banks? A. Pledge. B. Assignment. C. Hypothecation. D. Mortgage. 12. The charge on movable property to be created is known as A. Lying. B. Assignment. C. Mortgage. D. Hypothecation. E. Pledge. 13. Your branch in Chandigarh decides to sanction working capital limits to a public limited company and proposes to obtain equitable mortgage of immovable property of the company located in Jaipur. The registration of the mortgage will be required to be done. A. With the registrar of companies having jurisdiction over Chandigarh. B. With the registrar having jurisdiction over Jaipur if its registered office is in Jaipur. C. With both the registrars. D. With any of the registrars. 14. A loan extended by your branch is not paid by the borrower, which is secured by a mortgage. What should you as a mortgagee do? A. Approach the court to obtain permission to sell the property. B. File a suit against the mortgagor without selling the mortgaged property. C. Sell the property by giving a reasonable notice. D. Sell the property in consultation with the party. E. A and B. 15. In respect of a loan against a life insurance policy, which of the following value is taken as the basis for fixation of the loan limit? A. Face value of the policy. B. Net asset value of the policy. C. Maturity value of the policy. D. Surrender value of the policy. E. Any of the above, whichever is lower. 16. The limitation period of 12 years in case of a registered mortgage begins with reference to if the mortgage secures a term loan. A. Date on which the loan falls due. B. Date on which the mortgage was created. C. Date of documents. D. B and C, whichever is earlier. 17. In the usufructuary mortgage, the repayment of the mortgage money is A. Personal liability of the mortgagor. B. Not personal liability of mortgager, and loan is recovered from income from the property. C. Personal and property liability. D. No liability on the property or personal liability. 18. According to Section 3 of Transfer of Property Act, an actionable claim means A. A claim of debt, B. A claim of debt which has not been secured by mortgage of an immovable property, C. A claim to a debt which has not been secured by pledge or hypothecation of a movable property, D. B and C above, E. All the above. 19. Mumbai branch of the United Bank proposes to sanction working capital limits to a public limited company. The collateral security of the amount is equitable mortgage of the immovable property of the director of a company located in Ahmedabad. Where should the company get the charge registered for the mortgage? A. With Registrar of Assurances in Ahmedabad, B. With Registrar of Companies in Ahmedabad, C. With Registrar of Companies in Mumbai, D. With all of the above authorities, E. No charge is required to be registered. 20. Mr. Vikram Samant is sanctioned a loan of rupees 10 lakh for purchase of bill flat by United Bank under Bank's Housing Finance Scheme. Due to failure of the borrower to repay the dues in time, Bank filed a suit in a court which decreed the case in favor of the bank. When Bank initiated the decree execution, the borrower pleaded that he has only one house which he uses for residence purpose. Hence, it should not be a subject matter for sale. A. The plea of the borrower is not justified since the property is mortgaged and it is primary security for the bank loan. Page number 96. B. The borrower's plea is justified as the residential property cannot be subject matter of decree execution if there is only one house. C. If the borrower proves that he has only one house, his request would be accepted by the bank. D. It is discretion of the court to allow or disallow his request. 21. United Bank had granted a loan of rupees 12 lakh under its housing finance scheme for construction of a house to Mr. Atul Ghosh by mortgaging the house. On repayment of the loan, the bank had shown its inability to release the mortgage. Under which of the following rights Mr. Ghosh can force the bank to release the mortgaged property? A. Right of appropriation, B. Right of set-off, C. Right of subrogation, D. Right of foreclosure, E. Right of redemption. 22. In an English mortgage, the mortgager transfers to the mortgagee A. A specific interest in the property, B. As much interest as he wishes, C. The ownership of the property, D. Transfer of the property with all rights. 23. A loan secured by mortgage of immovable property is repayable on demand. The period of limitation in this case will be A. 3 years from date of loan agreement, B. 12 years from date of mortgage deed, C. 3 years from date of mortgage deed, D. A to C, whichever earlier. 24. In case of mortgaged money is repayable in installments, and mortgage deed contains a clause that in case of default for one or more installments, entire sum will become due. The limitation will be A. 3 years from date of the deed, B. 12 years from the date of mortgage deed, C. 12 years from deed of default, D. B or C, whichever earlier. 25. The charge assignment is governed by the provisions of A. Indian Contract Act, B. Negotiable Instruments Act, C. Transfer of Property Act, D. None of the above. 26. How many types of mortgages are there under Section 58 of Transfer of Property Act? A. 4, B. 5, C. 6, D. 7. 27. A company being a borrower in your branch has created an equitable mortgage. The registration under Section 125 of such a charge with Registrar of Companies is A. Required to make it binding on liquidator, B. Not required, being oral mortgage, C. Required sometimes when memorandum of deposit is submitted, D. A and C, E. Never required. 28. A search report from a legal counsel is insisted upon at least for A. 3 years, B. 10 years, C. 12 years, D. 30 years. 29. A mortgage under which the mortgager undertakes to repay the mortgage money on a fixed date. He also transfers the property to the mortgagee under the condition that on repayment of mortgage money, the mortgagee will transfer the property to the mortgager. Is called A. Simple mortgage, B. Usufructuary mortgage, C. English mortgage, D. Mortgage by conditional sale, E. None of the above. 13. In which of the following mortgages the loan can be recovered from income of the property instead from the borrower? A. Simple mortgage, B. Usufructuary mortgage, C. English mortgage, D. Mortgage by conditional sale. Answers: mortgage or assignment. 1. B. 2. D. 3. True. 4. A. 5. C. 6. C. 7. A. 8. True. 9. D. 10. E. 11. B. 12. C. 13. B. 14. E. 15. D. 16. A. 17. B. 18. D. 19. E. 20. A. 21. E. 22. C. 23. B. 24. C. 25. C. 26. C. 27. A. 28. C. 29. C. 30. B.